Yeah, I think everybody in my family, we kind of sit around at the end of the day up on my grandmother's porch, and I can remember my aunts and uncles and my parents talking about what was going on downtown, both during the 1963 movement and also prior to that with some, maybe individual kinds of protests and over hiring practices and so forth. Some of the issues that came up in the 63 movement. And they were all scared to death. There was this violence and this unsettling, and the whole world's going to get turned upside down and all that kind of stuff. And I mean, I don't make any secret about it. My family believed them. They were all white supremacists and, believes that black people are inferior to white people and all of this whole litany of horrible things, except for the fact that, I love them and they love me and they were good, decent people and good Christians at the First Baptist Church in Gardendale and all that. But they were scared to death of what was going on. And I think that was pretty typical of the way white people saw the civil rights movement. Now, in addition to that, I was working downtown at the time at Birmingham Book and Magazine, and a couple of times I just walked right into something like the arrest of a bunch of black teenagers who were not necessarily my age. I think they were probably younger. And I remember them being lined up against the storefront on 19th Street, downtown Birmingham. And I saw some other people fighting, boys. As I was walking to the bus one day, I walked right in the middle of a fight. So, yeah, I was scared. Well, I'm trying to write a book about that. I can tell you it has not been easy. But over a period of time, I changed my own racial views. It happened in college. I, among other things, became very close friends with several black people. A guy named Tony Harrison, who later ended up being in the state legislature, was a close friend of mine, and some of the black leaders in Tuscaloosa, including Joe Malisham, who's sort of a legend in Tuscaloosa. And over time, I gradually saw uh, the injustice of what had been going on in Alabama in my lifetime, and I decided I wanted to do something about it. Well, that's another thing that I've given some considerable thought to because I want to know for myself. I talked about my family a minute ago being racist and believing in white supremacy and all that, but they also believe that people should be honest and should tell the truth, and that treating people fairly was important, and that you should respect individual people. My grandfather Jackson was the first life deacon in the First Baptist Church of Gardendale, and he was a genuinely kind, decent human being. So those kinds of values, I think, dovetailed directly into the question of justice, inequality, and equal rights. I mean, it's all uh, based upon some really simple kinds of truths. And of course, many of those you can trace directly to things that Jesus said, the Christian religion. And you find the same kinds of thoughts in other religions too. So, what was it based on? I think it was based on everything that happened to me in my childhood. Some of it was reinforced and was helpful and was good and all that. Some of it was not good. Well, that was another important part of my life. By the time I got to my last year of law school, I was very active in the local civil rights group in Tuscaloosa and had been involved in a voter registration campaign that we actually, Tony Harrison and I got the money. We got it from the Voter Education Project in Atlanta and ran a voter registration campaign in west side of Tuscaloosa. And I would go to mass meetings of the movement in Tuscaloosa and got to know Joe Malisham and other leaders in Tuscaloosa. I was also very heavily involved in the anti-war movement, uh, not just in Alabama, but nationwide too. So I wanted to do something as a lawyer that would work within those areas. And I knew about the Selma project because Ralph Knowles, who was my longtime friend and later law partner, was on the board of the Selma project. Ralph had been president of SGA, and he knew the wife of Francis Walter, who founded the Selma project. So Ralph ended up on the board there, and Ralph said they want to hire a lawyer. So I applied, and they hired me. And that was an enormous education for me, those 3 years or so that I actually worked for the Selma Project, where I traveled all over the Black Belt and met every community leader in the Black Belt. And uh, a part of what the Selma Project did was to help economic development projects that came out of the grassroots of the Black Belt with very poor people, including the Freedom Quilting Bee in Alberta, Alabama. And most people know about Gee's Bend and the quilts. Well, Alberta's 10 miles away. And Alberta is actually where the sewing co-op was headquartered, yeah, in 68, 69, 70. And the building's still there today that was built by Francis Walter, raising money to build it. So that was a huge, huge influence in my life. And spending all the time I did with Francis Walter, who's a very wise, gentle, kind man, was helpful as well. I think enormous. I mean, I still uh, think not necessarily every day, but weekly, monthly, I think of things Francis said and stories that he told, stories I tell. And sometimes I tell people they're my stories, but they really came from him. And many of those stories involve extraordinary human beings who were very poor but resourceful, like Eugene Witherspoon, who was the husband of Estelle Witherspoon. Estelle Witherspoon was the manager of the Freedom Quilting Bee. And when we got White versus Stickney decided, one of the things that happened was Judge Johnson appointed advisory committees. Estelle Witherspoon was on the advisory committee for either Bryce or Partlow. I was trying to remember that this morning. I don't remember which. But anyway, I was talking about Eugene Witherspoon. Francis Walter had a bunch of stories about Eugene Witherspoon. So anytime I tell a Eugene Witherspoon story, it came from Francis. Well, I think it helped prepare me to be uh, a good lawyer by working with people who desperately needed my help, and I was able to do things that produced immediate kinds of results. I mean, and those things were really simple things. They weren't complicated. I mean, we helped people start daycare centers. Well, they had to be incorporated in order to be uh, officially recognized by the state of Alabama and be licensed. And they also had to be incorporated in order to get 501c3 status so they could get grants from foundations or others, even individual people. So drawing up a set of incorporation papers and getting a daycare center incorporated in Dallas County or Wilcox County, that really meant something to that community and to the people that were involved. And that was the kind of law I practiced for many, many years until I went to Birmingham and became a plaintiff's lawyer and handled more bigger cases and stuff. But most of my life, I was doing things for individual people, and most of those people needed me to do what I was doing. Well, it was almost like we were, in the same family or something. It's kind of, it's a curious set of circumstances, really, because we knew each other as undergraduates, but we were on opposite sides of the political divide in student government in Tuscaloosa, that campus at that time. And so Ralph became the candidate for student body president from one faction, and I was the candidate for the other. He won. But we continued to be friends and became better friends in law school. And when I went to work for the Selma Project, it was a job that he would have, without any question, been hired to do, except he had a year to go to avoid the draft. And so he taught school in Falkville, and I went to work for the Selma Project. I was exempt from the draft because I'm blind in one eye. But then when he got through doing the teaching for a year, he went to work for the Selma Project. We worked there for 3 years, then we formed a firm that represented the Selma Project and all its interests, but we had a private firm instead of being employees of the Selma Project. So he and I worked together just like we were like brothers or something. I mean, it was just a total trusting relationship, and one that lasted for a long, long time. But people move and change and all that. So he went off to Atlanta, and I ended up in Birmingham. But when we were in Tuscaloosa off and on for 20 years or so. Well, I knew who he was, because I read the newspaper and kept up with stuff he was doing. I also knew his son, Johnny Johnson, who was in school at Alabama while I was in law school. We were social friends. And, but the first time I met Judge Johnson was in the Wallace versus Brewer case, where we filed a lawsuit arising out of the purchase of land in St. Clair County by the Nation of Islam. And the state of Alabama and some private groups tried to prevent that from happening. They didn't want the Nation of Islam having cattle farms in St. Clair County. Tried to run them out of the county. Arrested Orzel Billingsley, who's a black lawyer, for filing the deed. on the trumped up charge that he was acting as an agent for an unlicensed foreign corporation when he filed the deed, which is absurd on its face. So anyway, we filed that lawsuit and won, and Judge Johnson was the convening judge of a 3-judge panel that heard it. And I don't think I'd ever met him before that, and I wouldn't call that really meeting him. I mean, he was the judge, and I was a boy lawyer out in the courtroom. I'd been out of law school like 7 months when we filed that. So, well, we always wanted to figure out a way to bring something in the Middle District because we knew we'd get Judge Johnson. We sued the Secretary of State, and then this guy, Ed Strickland, who was the executive director of the Alabama Legislative Commission to Preserve the Peace, had interjected himself into that by going up there and making speeches and handing out literature about black Muslims. You remember that's what they were called back then. And people, I mean, they were demonizing them in these meetings they had up in Pell City and places like that. So we were suing state officials located here in the Middle District. He was stern and scary and, just all business and absolutely in control of everything going on. Now, I saw that in Moore and White versus Stickney, where he was the only judge. Wallace versus Brewer, he was one of three, and the other two, one of them I think was Judge Reeves, and so Judge Reeves would have presided. So I probably didn't see that much of Johnson at the time, but still, my recollections of him are accurate from the total experience that I had. Yeah, I think it came from the fact that he was, in essence, the only judge in the Middle District of Alabama. I think Judge Pittman from Mobile picked up part of the caseload and would sit here sometimes. But basically, Judge Johnson was the only judge in this large judicial district. And so when he had um, a, uh, a case that presented constitutional issues and mainly a question of law, he would tell the lawyers on the front end, he'd say, I want all the testimony taken by deposition. You submit the testimony on the day of the hearing, then we'll have oral argument. So that's what happened in Wallace versus Brewer. First depositions I ever saw taken were in that case. George Dean took them, and I was his kind of gopher and assistant and helper, and learned how to take a deposition of George. He was absolutely the most formal judge that I can remember. You know, over 45 years, I appeared before lots of judges all over the United States. And Johnson was the most rigid, ramrod, kind of straight looking and acting, and everything was absolutely done, by the rule book. He had they call them courtroom deputies. He had this man who was from up in Russellville somewhere who was his bailiff, is what they called him back then. And Judge Johnson, rather than say the court will be in recess, he would turn around like this and he'd look at this guy and he'd say, recess 15 minutes. The guy would then announce it like it was a court crier in 1900 or something. I mean, everything was very, very formal. And that added to the intimidation factor a great deal. And well, you know, it was very serious, very controlled, and you just never saw anybody kind of joke around or play. It was sort of like having Nick Saban be the judge or something. I mean, people were scared to death of Judge Johnson for the most part, and with good reason. I mean, he was very, very firm and strict, and um, actually, I learned from some of the state court judges I tried cases before that for the most part, was a blessing to control lawyers. I used to try cases in Tuscaloosa before judges who were afraid of lawyers because they had to get elected and let lawyers do anything. It's hard to try a case if you've got lawyers screaming at you and interrupting you and hollering you and snatching things out of your hand and all. I mean, all those kind of things happen to me at some point. I liked him. We were always prepared. We were ready to go. When he said go, we went. Yeah, I can tell you several of them. The first one was at a state bar meeting. And I don't think you know about this because I don't think I've written anything about it that you could have read. But it was in Mobile at the old Battle House Hotel. And there was a program about to start, and it was downstairs where this big ballroom was. So I was going to go down there to hear this, and it was like one guy was going to speak, and then there was going to be a panel, and Judge Johnson was going to be on the panel. So I got on the elevator, and the elevator came down, and the doors opened, and so I step in the elevator, and here I am in an elevator with Ruth Johnson and Frank Johnson, nobody else. And Judge Johnson looked at me and he said, Jack Drake, Ms. Johnson. And Ruth Johnson said, Oh, are you Jack Drake? And I said, Yeah. She said, Oh, I'm just so happy to meet you. She said, we agree with you on everything. She said, I am just as left wing as you are. And I nearly died. I mean, I just did. I absolutely could not say anything because he was standing there. Of course, he wasn't saying anything either. And so the elevator went down one floor and the doors opened and they got off and I stayed on. I just couldn't. I said, how the hell with that? I'm not going to go to this meeting. I went back up on the elevator and left. He went and got in my car and came back to Tuscaloosa. I was so scared of that little encounter. Um, and I think there were a few other times where I would run into him later on, and when I'd go to 11th Circuit judicial conferences and things like that. But another strange thing with Ruth again was this was years later after he'd gone on the 11th Circuit, and there was an 11th Circuit judicial conference meeting at the Grove Park Inn in Asheville, North Carolina. And so I was there with my partner, Joe Watley, and we walked in this big cocktail party that already started. It was outside. And there were a lot of people around, and here was Ruth and Judge Johnson standing there. And so I just walked over to him and I spoke to Judge Johnson. And then I turned to her, to Ruth, and I said, Hi, I'm Jack Drake. She said, No, you're not. And I said, Well, yes, I am too. She said, No. She said, I knew Jack Drake and you're not him. And Frank Johnson said, Honey, he's just gotten older. And she said, No, I knew him and this is not him. And I thought that was one of the strangest things that ever happened to me. George Dean and I worked on that Wallace versus Brewer case together. And we met each other that way. And then George and I got involved in some student mass arrests in May of 1970 in Tuscaloosa, where students were protesting the invasion of Cambodia, and over 225 students got arrested, and we represented most of them. So while George was there working on that case, 100 state employees were fired or their jobs were eliminated at in the Department of Mental Health, mainly at Bryce Hospital, and I think at the hospital in Mount Vernon, South Alabama. Those two were in, but there a lot of those people whose jobs were terminated lived in Tuscaloosa, so they hired George. He filed a lawsuit in federal court in Montgomery, and Judge Johnson had said something to the effect that he had some doubts about whether the state employees had a valid claim or not, but that the patients, and George had put a patient in as a plaintiff named Ricky White, and that, Judge Johnson said, well, maybe patients have a claim. I don't know. Anyway, toward the end of 1970, George asked me to come down to Destin to go over the case with him, and he said, do you think we should amend the complaint to allege that the patients are being denied adequate treatment? And I said, yes. And he asked me that because he told me before I came down there that I'd done some reading on what the law was. And there wasn't much, but I'd read what there was. So anyway, we amended the complaint to allege that the termination of these employees meant that patients who were involuntarily committed were not receiving adequate treatment, and that they had a constitutional right, since they'd been denied their liberty, to be treated. And we had a trial on that a lot of people don't remember because it was the first one. But that was in early 1971. There was a court decision. Judge Johnson ruled that there was such a constitutional right and that it was not being accorded to people. But instead of doing something drastic, he gave the state of Alabama 6 months to come up with a plan to provide adequate treatment. So from late 1970, I was in the case with George, and we went through that first hearing, tried to get Judge Johnson to do a lot of things in terms of remedies after the state filed its plan, which was just ridiculous. And Judge Johnson wouldn't do that. I mean, he didn't do the things we asked him to do, like appoint somebody to run the whole system. That would have been pretty drastic. And then the big hearings were set in May, I think it was May of 72. And that's when the rulings came down with all the standards of care and so forth. Most of those standards were negotiated, by the way, agreed to by the state. There was just the ones involved in the ratio of professionals to staff, and some few others were not agreed to, and that's what we really tried the case on. We had about a 3-day trial in the big courtroom down the hall from right where we're sitting, and then all those standards came out that are the real basis and the real heart of White versus Stickney. Well, they were beyond atrocious. We went through a lot of the facilities at Bryce and at Partlow. And, there's one place at Bryce I think we called it Ward C, and that may have been what it was. I'm not certain that's the correct name, but there were people who were naked all day and were acting out, schizophrenic, talking to themselves and to imaginary people. We had detention rooms where people we found had been locked up for 12, 13 years, never gotten out, for anything. You just had a massive warehousing of people at Bryce Hospital. There were over 5,500 people at Bryce Hospital at that time. And then at Partlow, the conditions were where you had people who at that time were called mentally retarded people. It wasn't so much masses of people who were allowed to just kind of fend for themselves. You had people who were unable to fend for themselves, who were neglected because of staff shortages. And one thing that I did for the big trial was to go to Partlow and go through the files for everybody who died for the preceding, I don't know, maybe 5 years, something like that. And I found these horrible circumstances where higher level residents, as they were called, would be punished by saying, go get this bedridden patient who was not ambulatory, had an IQ of 30 or something. I mean, really helpless people almost, bathe him, clean him up and all that. And one of those people was scalded to death with hot water by 2 other residents. Another one had a garden hose stuck up his rectum and filled up with water, and his organs exploded. He died. Found people who would get up in the middle of the night and go into cabinets that were supposed to be locked and take 100 pills and die. People who would die of pneumonia because nobody looked at them. It was really horrible things that were going on within the hospitals. And, when Judge Johnson heard all that, he sat on that bench in there at the end of that hearing and ordered the state of Alabama to suspend the merit system and to hire 300 people in 2 weeks. And most of those people were going to work at Partlow to keep those kind of people that we're talking about from being killed. But also at Bryce, too, because at Bryce, you had one staff person sometimes at night watching over 200 people. And you can just imagine what happens when that's the circumstance you got. So it was a horrible situation. Well, it was very disturbing, uh, but I mean, when I was young, like back in those days, seeing people being horribly mistreated just really thoroughly pissed me off. It made me mad and angry, and I wanted to do something about it. And I mean, the human suffering affects me more today than it did back then, because back then it was just sort of like another motivating factor to make me do something. And, but it had a big impact on me, no question. I could see a judge doing that under some circumstances, but that would have been rare at that time. It would have been very unusual at that time. And Judge Johnson, had been a U.S. attorney before he became judge. He appointed the Justice Department to come into Wyatt versus Stickney as a friend of the court. And he appointed Ira DeMint, who later became a judge here, Ira was the U.S. attorney, and Judge Johnson appointed Ira DeMint to come into the case. And Judge Johnson believed, well, I'm not sure how much of this is true, but I think he used to talk to Ira DeMint a lot because he thought that was not a conflict of interest, because Ira DeMint was, in effect, working for the court, so to speak. And so he had some eyes and ears on the ground. Ira DeMint went through. And when Ira DeMint went through Ward C at Bryce Hospital, he went to the restroom and threw up and washed his hands and arms and face and everything. I mean, he was a basket case coming out of there. And I'm sure he told Judge Johnson about it. Well, the White standards were the best thinking of mental health professionals and lawyers at that time about what it took to provide adequate care for institutionalized persons in mental health facilities. And the American Psychiatric Association, the American Psychological Association were friends of the court in the case and had lawyers in the case. The Mental Health Law Project had lawyers in the case, and they were a great advocacy group. So those standards were, the gold standard at that time. And they became standards that were utilized both by other courts, by advocacy organizations, and also by international organizations, United Nations. When Judge Thompson closed the file out, he had a long list of the impact of the White versus Stickney standards, and I've just kind of brushed on some of them, but there were many. People believe that those standards became the basis for the regulations for the Americans with Disabilities Act, for the regulations promulgated under that, for certain parts of them anyway. And I think of any kind of institutional litigation, the White versus Stickney standards were the most sweeping ever issued by a court in the United States in history. Well, the parties negotiated over some of them and agreed on them. And the department at that time wanted to bring about as much change as it could through the litigation and still kind of live with itself and live with the money that it had to operate. So some of them were agreed upon. But what Judge Johnson did in the trial, where those were not agreed to, he essentially ordered the state to implement the standards and set the standards based on what the state of Alabama's lawyers said. He took the more conservative approach over like staffing ratios. And, but, the standards were so detailed that in some ways, by the time you got around to doing the staffing ratios, they had already given away the farm. The state had, because you can't have, for example, a requirement that every patient has a right to see a mental health specialist or therapist once a week if you have that in your standards, or people have to be seen by a dietitian, or there has to be a plan drawn up by a dietitian, or You have to have this standard or that standard. You had to have people in all of them to make those standards work. So uh, he took the conservative approach, but even the conservative approach was thought by the mental health advocacy groups to be wonderful compared to what was going on in the country. I mean, when I describe Bryce and Searcy and Partlow, that's the way most mental hospitals, public ones in the entire United States were. That was the picture. He appointed a monitor to, and that wasn't the very that didn't happen immediately. It took some time to do. And then he had a monitor staff of people who the monitor had a budget in an office, and the monitor's job was to make sure the standards were being implemented. And the monitor had a staff. And one of those monitors, the first one, I guess, was Liesl Gray, who was Judge Johnson's longtime friend and fishing buddy. But Liesl Gray also had been probate judge of Walker County and was an insurance company executive, a very skillful, bright, capable person. He wasn't just, I'm going to let my buddy do this kind of thing. He put somebody in there who could do it and did a very good job. And Liesl Gray hired a first-rate staff to help him. When we had gotten pretty heavily into Wyatt versus Stickney, it became apparent that the civil commitment statute had to go. I mean, it was antiquated. You could commit people for being addicted to alcohol or tobacco. The practical matter was that probate judges would get a telephone call from somebody they knew, say, Aunt Sue or my daughter or my son or my brother is acting out again, and we need to send him to Bryce. And the judge say, okay, just come by here and I'll give you an order, sign an order, no hearing, no right to counsel. Deputy sheriff shows up at somebody's house, I've got an order to take you to Tuscaloosa. So we wanted to do something about it in Wyatt, or at least I did. George Dean wasn't particularly interested in that. I think he thought he had enough to do as it was. So, but I was looking for a case, and so one day this woman named Jean Lynch made an appointment to see me. She had been committed here in Montgomery, same way I was just talking about. Deputy sheriff shows up at her apartment with a court order. She gets taken off to Bryce Hospital and stays 2 or 3 weeks or a month or something, and then they let her loose. And so she came to see me. Well, we had us a perfect kind of fact situation because she had not had a hearing, not had a lawyer. It was exactly what you wanted. And I asked George, I said, George, I've got a case. You want to be involved in this? He said, no, I ain't got time to do that. So Ralph and I did it, and we filed a lawsuit. And the statute was declared unconstitutional, which we knew it would be. And the whole fight was over remedy. What do you do? Now that you said the statute's unconstitutional. And Judge Johnson went the extra mile, whereas a lot of people wouldn't. I mean, it wasn't just him. It was a 3-judge panel, but I think Judge Johnson was sort of the dominant figure because by that time he already had the White case. And what they ordered was everybody who had been committed under that statute had a right to be a new hearing with a lawyer. And it took, I think, about 2 years to get all of that done. Judge Davina, Joel Davina, who's on the 11th Circuit and is from here in Montgomery. He used to have his office here. He's next door, I guess he is. Anyway, Judge Davina was a lawyer who was involved in that. I think he represented the State Department at the time, and he has talked about it fairly often, including the University of Alabama Law School. But those recommitment hearings emptied out Bryce Hospital. I mean, you had 700 or 800 people that just left, maybe more than that. I wrote an article once. I had the actual numbers in there at the time. But Lynch versus Baxley was very important in the mental health litigation because it, more than White, actually got people out of the hospitals who weren't supposed to be there. Well, it's easier to say now than it would have been 35 years ago. There's no question that White was the spearhead for massive reforms in mental health treatment and the way mental health institutions were run in this country. And it just sort of became the catchword that people needed in Connecticut or California or Colorado or Texas to bring about reform in those states, some of it by statute, some of it by court decision, which had massive reform all over the country, which was a good thing. But with the deinstitutionalization, what you had to have was an adequate community-based mental health program that had active treatment, including institutional treatment where needed, with all sorts of social worker support and social network support for mentally ill people. And that support system never came about. State legislatures weren't willing to fund it. Congress wasn't willing to make them fund it. And so as the institutions were closed, what we found and what we have today is that we had mentally ill people who were basically put out on the street to fend for themselves, and a very high percentage of them have ended up in our prison system and in our jails. And so we have a situation today that in many ways is worse than what we had when we had the large institutions, because the large institutions did function in some ways as asylums. An asylum, in the original meaning of the word, is, a safe place. And what we don't have today is a safe place for these very fragile people who are mentally ill, and they end up in the prison system. And of course, you've got litigation going on right here in this court now about all of that involving the Alabama prison system, where people routinely die from neglect, kill themselves, the kinds of things you found in the mental institutions of 50 years ago, but not on such a dramatic scale as you see in the prison system. Oh, I think that those tools enable courts to manage complex litigation and the effects and the impact of complex litigation on state institutions. The special master or court monitors are a wonderful way for a court system to run a system if it has to. And I wish we had seen more of it in some situations. I mean, you look at the Alabama prison system, somebody should have been running the prison system for the last 10 years, other than the people that are running it right now, because they are allowing people to die every day in the state prison system in Alabama who should not die. We don't know, obviously, but in spite of his rigidity and doing everything by the rule book and everything, I think Johnson was very flexible when it came to what he was going to do with the case in front of him, because he had to do something with it. And he was very creative and I think quite flexible in the way he went about it. So probably he would have been fine with it. I thought from the time all these national organizations got involved in the case, and they really did the work on the standards, they were the experts, they and their lawyers. I thought from the time that happened that we were looking at something that was going to be one of the most important cases in American history. And I still think that. Well, it was a wonderful experience to go through. But I have to say, looking back on it, I mean, it's the truth that I worked on Wyatt for years and years. I think I made $20,000. So how did it affect me? It meant that I didn't make very much money for the first 10 or 15 years that I was a lawyer. So that's one way it affected me. Oh, yeah, those were our cases. And I mean, I was not personally the lawyer handling them, it was Ralph Knowles. But we were in Pugh and Newman cases. And those are the two big prison cases that Judge Johnson handled. And then they later went to other judges after he went to the 11th Circuit. It was similar in the sense that you had the state prison systems that were being run in unconstitutional ways. People were being denied just the right to be in a safe place and not be harmed by other prisoners or by guards. They weren't receiving nutritional food, diet, didn't get proper exercise, weren't getting medical care, adequate medical care, weren't getting adequate dental care. They were being arbitrarily punished in ways that could kill somebody, like being put in what they call the hot box, which is a plywood kind of box out in the middle of a yard when it was 100 degrees or 95 or something, and you stick a person in there and there's a hole where they can breathe through. People would overheat and die or have heat strokes. And summary punishment where guards beat people. And so the standards addressed all of those kinds of things, all of the conditions for individual prisoners in the state prison system. You had staffing ratios, types of staff, food regulations, and so forth, very similar to what was done in Wyatt versus Stickney. And then you had implementation problems, oversight, and Ralph Knowles actually at one point stopped being a lawyer in the case and became a member of the oversight committee that helped run the system. He did that for several years. They were very important cases, but, I'll have to say, here we are in 2023, and the state prison system is in worse shape today than it was back then.
How did that happen?
I think it happened because of continued inadequate funding from the state of Alabama and a period of time where there was no litigation, there was no oversight from the courts, and then you have a period of time where there has been extensive litigation and the court has not really been able to enforce its orders and standards in a way that has produced results. And I say that as somebody from afar because I'm not in those cases, so I don't have knowledge of the day-to-day kinds of activities. But I know there some terrible things have happened in the prison system over a period of the last 10 years. Things seem far, far worse to me today than they were in, say, 1980. Well, he was absolutely right. I think he said it was the Alabama punting syndrome, something like that. The state punted the ball to the federal government. And, Alabama's been doing that kind of thing throughout its history. And one of the problems in Alabama is that our tax base is so inadequate that state government's never been adequately funded at any level in its history, I don't think. Well, mental health and the state prisons are the two obvious examples, but uh, if you look at the whole area of public education, yeah, the standards that have been applied in public education for performance monitoring and or standards for uh, what high school students ought to study uh, to have a high school degree that actually means something. Any kind of standard like that you ever want to think about, they were never developed by a state agency in Alabama. It always comes either from the federal government or from a consortium of entities, other states, or other organizations, Chamber of Commerce, whatever, like Common Core, you know, those kind of standards that are developed somewhere else, and the state of Alabama latches onto it. And it, or look at any kind of environmental law, the state of Alabama does what it is made to do, required to do, either by the federal government or by a federal court. And many times they don't do that. I think his legacy is that he was someone who was willing to decide a case to protect the rights of the litigants before him and those affected by the ruling without regard to the personal consequences to him, how he would be seen or perceived. I think he literally believed in the rule of law and applying it evenly across the board to everyone, no matter what. And, that um, that's unusual. There haven't been many like him, or, I can think of a couple others, but, and of course, he was in a situation where he was at a time where there were gross violations of the law going on that no one else would do anything about. And not everybody gets to live through that kind of a period of time. He did, and he stepped up and he did what was right. That's his legacy, I think. I think exactly that he was fair, that he believed in the rule of law. He believed in people being treated equally before the law, regardless of their circumstance or stature or economic situation. I will tell you one story about George Dean that I didn't mention. The state of Alabama brought Carl Miniger to testify for them during the White case. Carl Miniger was like America's idea of what a psychiatrist is supposed to be like. He was like this much beloved public figure, and he had run a hospital in Kansas, the Miniger Clinic, and he had this philosophy of involving all kinds of people in the treatment of mentally ill people. Basically, it was a way to provide treatment without much money because you'd use everybody who worked there in the therapy plan. And Miniger was such a big leaguer that he got here to this trial and he had to stand out in the hallway for 2 or 3 days. And he was just furious at being treated like that. He was in his 80s at the time, I think. And he was really mad. And so he comes in, he finally got to testify. And the Justice Department had a lawyer who was like a geek, just this guy he was so excited to be in a real case and examine witnesses and everything. So he decided he was going to destroy Carl Miniger on cross-examination. He started asking him about hydrotherapy, where you put people in hot water, take them out and put them in cold water, things they did back in the 20s and stuff. And so George Dean, who was this crazy man, was sitting there listening to it and just getting furious, this guy. And he's looking at Judge Johnson, and Judge Johnson's probably thinking the same thing. So George gets up and he goes up behind this guy from the Justice Department, and he puts his hand around the guy's ear and he says, "He had a stroke out in the hallway and you're about to kill him. Will you shut up?" And then he sat down and the guy like this, and he said, "Judge, I think that's all." And he goes and sits down. And George would do things like that in front of Frank Johnson, in Frank Johnson's courtroom with 300 people sitting there in the middle of this biggest case going on in the United States. And he goes up and tells somebody something like that.
That's it just seems like you're really going out on a limb to do something like that in Judge Johnson's room, given what you described.
Yeah. Well, I think maybe Johnson knew what he was doing, or maybe not those words, but the guy did sit down.
Yeah.
George was a guy who was, a Korean War veteran who's ended up in Korea in the middle of his college career, while he was an undergraduate. He was a young guy. And he led a team of people who would go across enemy lines maybe once a week or twice a week, something like that, and do sort of scouting, see where the troop placements were at night, and ended up in a lot of very close firefights and with a lot of people getting killed. And he did that for a year. So then he came back to the United States and finished up his undergraduate degree and went on to law school. I think he was editor of the Law Review. He was a very smart guy. And he was literally not afraid of anything. He would do crazy things. We went to a judge's house one time at 4:00 in the morning because he wouldn't allow students to make bail in Tuscaloosa. And, here's George ringing the guy's doorbell at 4 a.m. and screaming through the door. We just wanted you to know that there are 125 kids in jail because you won't set bail. He was not afraid of anything. Anyway, he was a great lawyer too. Well, I think there are times when you do need people who are willing to just, take on the giants of the world, or folks that look like they're giants, and take them apart. And George could do that.